Hello, everyone, and welcome to the 6th webinar in our disaster webinar series. Today, we're going to hear about FEMA appeals with Tracy Figueroa from Texas Rio Grande Legal Aid. Tracy leads TRLA's Disaster Assistance Group, where she has coordinated their response to at least 17 federally declared natural disasters. I'm Kathy Grunwald, the disaster coordinator attorney at Legal Services in North Florida, and I'm here today with Carlin Selders, our disaster program assistant. A couple of things before we get started on the webinar today. If you have questions, just type them in the Q&A tab at the bottom of the screen or in your webinar taskbar, and we'll respond to as many as we can at the end of the webinar. The webinar today is being recorded, and I'll email you a link to the recording and Tracy's PowerPoint once we get the editing done, so that'll be about Tuesday or Wednesday of next week. The webinar has been approved for Florida CLE credit. The number is 2,806N, but I'll send you that information as well. After we get done, you're going to be asked to complete a short survey, and I hope that you will do that and give us feedback on this webinar. And thank you today for joining, and I hope you'll come back next week for our 7th in our webinar series. And so with that, I'm going to turn it over to Tracy Figueroa.
Hi, everyone. I'm glad to be here talking to you about this topic today. In the time that I spent at TRLA working on disaster assistance matters, I've spent a lot of time working on these appeals, and I think they're really important. So this matters because it's been the #1 post-disaster legal need that we've seen, disaster after disaster. Sometimes, depending on the event we're responding to, and over a long period of time, it might be like 50% of the cases that we see. And then in some situations, it's been more like 90%. It's important for the legal aid folks to be involved in this because these legal issues are not typically addressed by the private bar. And it's been exciting to see in more recent years, more pro bono attorneys engaged in this really important issue. And then there's a very high volume of these cases that arises, and the deadlines run very, very quickly. And so getting this training now, whether you are doing it to prepare for something in the future or actually responding to something like Hurricane Sally right now, it's great so you can kind of hit the ground running as you're working on more and more of these cases. It's also important to note that it's not just about the amount of FEMA money that a person will receive. There's kind of a snowball effect if they don't get FEMA assistance that they might be eligible for because maybe they don't appeal or they don't appeal in a way that is going to actually change the outcome. Then it can lead to other kinds of legal setbacks. There's a variety of disaster-related legal needs. I know some of these are being addressed in other portions of this series. But just as one instance, if they don't get enough money to repair their home, they might be more likely to stretch their money by hiring the contractor they can afford, who may not be someone who's going to deal with them fairly. And then they have a different legal problem on their hands. And then there are other publicly and privately funded programs that actually depend on the decisions that FEMA makes about the amount of damage to homes. It could be on an individual basis. For instance, Red Cross in the past has had some programs where, because Red Cross wasn't sending inspectors out to people's homes, Red Cross was using FEMA's decision about the amount of damage that someone had to decide eligibility for some Red Cross funding. So the FEMA assessments impacted the clients twice. And then sometimes there's kind of this global approach that the FEMA assessments of damage to people's homes were considered in decisions about how large amounts of federal funding, like community development block grant funding for disaster recovery, was distributed. So these decisions matter for some larger reasons as well. So, and there's a lot to say about doing these kinds of cases when you're going to do them in volume. My goal with this is to do just a pretty high level overview with the time we have today. I'm going to emphasize as I move through some of this pretty swiftly. The last slide is going to have my contact information. I'm happy for anyone to contact me afterward for additional information on some of the details I'm just going to kind of touch on right now. And then Kathy Grunwald from Florida, she is going to be the person to contact about some of the Florida specific angles to this. But okay, so the basics. Understand that FEMA is just one part of how people are able to get some assistance to work on disaster recovery. And it's not always the first thing. Generally, when you have an event occur, Red Cross is on the scene immediately. So the shelters that are open and available to people, sometimes financial assistance, it's pretty limited in scope. We're generally looking at Red Cross and the volunteers there. And then other voluntary relief efforts, that's vague because it changes disaster to disaster and community to community. So the churches and long-term recovery groups and nonprofits that do things in Corpus Christi, Texas, where I'm based, or other parts of my program service area, El Paso, Texas, are different than what it's going to look like in your different communities where you are. But it's important to find out who those partners are in your community so you can stay in the loop. And key to disaster partnerships are always a big thing, and you don't really want to be forming those for the first time after an event. So just kind of stay plugged in with those efforts as they exist. But in any event, that's a great source of help for people, especially in the immediate aftermath of a disaster. Insurance proceeds for people who have policies. Small Business Administration disaster loans. They're not just for businesses. That name kind of is misleading for folks who are unfamiliar with the program, but there are some low interest loans that can help people with their recovery. And then FEMA benefits kind of fit in there, and then welfare benefits, which people may have been eligible before the disaster, or they might not have, but their circumstances changed. And then there are a few forms of welfare benefits that are disaster specific. Disaster food stamps is one example of that. Also, FEMA money is not available in every disaster. What we're looking for is a federal declaration of a major disaster for that you're concerned about. And we're looking for declarations that provide for individual assistance. So sometimes people will note there's a news article, it was already declared a disaster. Well, you have to look and see, are we talking about a declaration that provides for individual assistance? Because there's some other types of programs and benefits as well. And then just to kind of show what we're honing in on here, there are multiple individual assistance programs, but we're talking really about one today, the FEMA Individuals and Households Program, abbreviated IHP. When we're talking about FEMA giving funds to people, it's FEMA IHP generally. There are two parts of IHP. There are some subcategories underneath each. One of the slides here is going to set that out. I'm not going to unpack all of those for today, but just know there is housing assistance and not housing assistance, okay? And we call the not housing assistance other needs. But the housing assistance, that is only federal. FEMA's making the decisions. The federal government is funding what goes through there. The non-housing part, other needs assistance, that's the federal government and the state working together. And saying that pretty vague because there's a few different ways that that can work, and you would just have to look at how it works in your state. Texas, where I'm based, we have a bifurcated system, and the Texas agency actually makes the decisions on other needs assistance. And I won't get into more detail there, although if you're ever working on these appeals in Texas, do reach out and I'll be happy to explain more about how that works. But just understand there's that distinction, so you ask questions of the practitioners in your area who do know how it works. And then there are caps on the amount of money that people can get for FEMA IHP assistance. That's actually been a big change since 2018 when we had the Disaster Recovery Reform Act. We used to just have one cap for everything. Now there are two caps. There is the cap for housing assistance, $36,000 for the current fiscal year, which just started, and then $36,000 for non-housing, your other needs assistance. There are a few categories that are not counted against the cap too. So rental assistance is one of the types of housing assistance that is not going to count against the cap of $36,000. And that can be important depending on how much a client might need for repair assistance for their home and such. And then there are certain expenses for housing assistance and other needs assistance that are payable and also not counted against the cap. And that has to do with expenses related to accessibility for persons with disabilities. So more information in the authority that provides for that. So just at a glance here, these are the categories of FEMA IHP, the ones that fall under housing assistance. The ones that I deal with most often are temporary housing assistance, or depending on how it's arising in your cases, rental assistance. And that's for someone who cannot reside in their home after a disaster because it's not safe to do so, uninhabitable in FEMA's opinion, or if it's not accessible. Think of a second floor apartment, maybe that's untouched by a disaster, but every other apartment in the complex was damaged by flooding or hurricane, and maybe the complex is just off limits while it's being repaired. So somebody can't live in their unit because it's inaccessible. So in those situations, somebody may receive temporary housing assistance so they could live somewhere else for a while they're displaced. And then home repair, that's the other one I've spent a lot of time working with clients on, the need to be able to get enough assistance to restore their home to a safe, sanitary, and functional condition, as FEMA defines that, to make it habitable. And these other things, I want you to know they're out there, but they just have not come up in the many disasters I've worked on, but it could come up in a disaster you work on, it just depends. Other needs assistance, the bulk of the cases that I've worked on have involved personal property replacement and transportation assistance. I'm going to have some more slides that explain the issues in that, but just for now, know that those are some of the categories. Medical, dental, funeral expenses, you're going to have that relationship, that nexus with the disaster. Childcare, again, some specific requirements there, but it's going to have, again, with that nexus with the disaster that's been declared. Critical needs only comes up sometimes. I saw that after Hurricane Harvey. So I'm thinking more catastrophic disasters, but it's not always an option, but there's some specific definitions under there. And then there's this other category within other needs assistance that kind of is a catch-all, but may allow for something unique in certain events that you work on. Where do you look if you need more information? Okay, so the Stafford Act is the set of statutes that has to do with FEMA and disaster work, but this particular statute, 5174, sets out what you need to know about the individuals and households program we're talking about here. There are 10 regulations that would tell us more about like eligibility criteria, appeal procedures, and such for the IHP program. So set out there, 44 CFR 206-110 through 206-120. FEMA has published its Individual Assistance Program Policy Guide, and the version that is available now was published in, I think, early 2019. It does not factor in yet the full set of changes that were wrought by the Disaster Recovery Reform Act in 2018. So watch for any discrepancies there. Obviously, lawyers know statute will control over a policy statement that conflicts, so you kind of have to watch for that. But there is a lot of information in this guide that's 200 plus pages. And I'll also note it's Individual Assistance Program Policy Guide. It is not just about the IHP program we're focused on here, but there is a component of that resource that does describe more about how FEMA says it's making these decisions in these cases. And then FEMA's website has a number of different press releases, other general information, frequently asked questions, and some publications. So you can look to see if the question you need answered may be represented in something there. And then just a quick note, FEMA published this year a draft version of that policy guide. So while the one that is online right now was published in early 2019, they actually have worked on a draft to update it. It was published for comment this summer. I don't know when it will be published again as a final version, but keep an eye on that if you're working on these cases, because there might be an updated version of that guidance document then. Okay, the FEMA IHP process and eligibility. How does this all work? So generally, I think it works best for my clients when they're applying with FEMA when we already know there's been a federal declaration for their county. I understand that it is possible for applicants to actually call FEMA and apply before it's been declared in their county, but they will get a denial letter then. And it will say you're not eligible because it hasn't been declared in your county. I understand that, again, this is historical, so, but they will reprocess applications for people if that county later gets added to the disaster. So your client may, without further action, get a letter later saying, now we're going to process your application because you're in that county. But I've had clients worried about the fact that they are told that they weren't eligible, kind of confused by that process. So that's why I emphasize it makes sense to me that they apply after they already know that declaration's occurred. Excuse me. It's generally a 60-day period that someone can apply after it's been declared. Sometimes that's extended for various reasons, so just keep an eye on that deadline. If that deadline has been missed, don't be discouraged. Go ahead and try to apply late, but explain why, and explain why you think there's good cause if that exists. There have been some situations, for instance, someone that was like hospitalized and wasn't able to meet the deadline because of that. So that has generally been an argument that has been persuasive in explaining to FEMA why the person should be allowed to submit a late application. Other situations might work, but just, I recommend in general, try. And then how to apply, it could be done online. There's a mobile app. And then if it's by telephone, the person who wants to apply is relaying their information to FEMA to type in. So just a copy may be sent to them after. It's really important to look over that to make sure there weren't any typos and addresses and different things then, but it can be done by phone. There are other eligibility requirements. I'm not going to go through all of that here because our time is limited. I'm kind of trying to hit points that I think people get stuck on in my experience, but this is an important one. Only United States citizens, non-citizen nationals, or qualified aliens may be eligible for this program. Qualified aliens is a very specific definition that is set out. So there are materials that, unpack what that means. It's important to consult that in an immigration attorney if necessary, if you can't determine it based on the definition. But you only need one eligible person in the household. Again, it's the Individuals and Households program. So if you have multiple people in the household, you're still getting benefits, under one person's name. So it could be any adult member that qualifies. They could be the head of the household. But even in situations where the eligible person is a minor child, you could have a parent or guardian within the household apply on their behalf. I have to just kind of add this caveat. This is a decision for the applicants to make and just be informed about the issue. But the FEMA form does contain some detailed household information. While the Privacy Act applies, and so the information is protected, they would ultimately have to acknowledge that the information could be shared by FEMA within the Department of Homeland Security and including some immigration enforcement folks. So I have not, in my experience, seen an immigration proceeding result from information that a client shared as part of this process, but I can't give anyone assurance it would not happen. So just something that people need to be aware of. But having a citizen child in the household is enough to be eligible for the household benefits. Some other just kind of highlights of eligibility. You cannot duplicate benefits. So if there's one source that is paying for something, we're not going to be asking FEMA to do the same thing. Certainly that's true with insurance benefits. So an advocate working with a client that has an insurance policy, you need to really understand what is and isn't covered by insurance so you can make that clear as you are seeking assistance from FEMA. The home has to be in a declared disaster area if you're talking about housing assistance. And then I mentioned this factor earlier, but is the home something that is habitable or inaccessible? Those things have to be considered for certain forms of housing assistance. For other needs assistance, we're talking about losses that are in an area that's been declared to be part of the disaster area. And we are only talking about necessary expenses or serious needs due to the disaster. This is not the same scope that somebody might have covered under an insurance policy. If you have insurance, that is to more or less make you whole, depending on what types of insurance you have and the extent of your policy. FEMA's different. It is a narrower scope. It's supposed to meet these kind of necessary expenses and serious needs. And then there are some forms of the FEMA assistance that FEMA is not going to be able to even consider giving to someone unless FEMA's records show that the person has tried to get an SBA disaster loan and that they were not awarded that by the SBA, because they're wanting to be more of a last resort. An SBA, if they can take care of that need and the person was eligible for it, then FEMA doesn't need to spend money on that program. So just be aware of that when your clients are hoping for some forms of other needs assistance. They need to understand their need to pursue the SBA loan. Okay, inspections are really important in this process. And so TRLA's work has involved working on many individual assistance cases for individuals, but we've also pursued some litigation against FEMA to challenge certain practices. And as part of that, we've learned more about the inspection process as well. So kind of combining these sources of knowledge here, but FEMA will usually promptly inspect the property of the applicant in person if certain damages have been alleged to have been caused by the disaster. And the person that FEMA is sending, the inspector, is to establish whether or not the home is uninhabitable, whether or not repairs are needed or replacement in certain instances, whether other property damage occurred. So, whether the living room set was destroyed because there were several feet of water in the house and so on. Verify ownership. So it's the inspector that is generally laying eyes on the paperwork to show whether or not someone has proof that they own the home or meet FEMA's owner standard, and a verification of occupancy, that the person actually resides in that home and it's not their vacation home or something. Now, FEMA will emphasize, and it makes sense, inspectors do not decide eligibility. That's a conclusion. But they are FEMA's fact finders. They are the eyes and ears that are going into the homes to make decisions that eligibility is going to be premised upon. We understand that, at least historically, most of the initial decisions made in FEMA cases are automated. Computer formulas utilize information that is part of the file, including the finders that inspectors enter when they are at the home and upload. And that can spit out then an eligibility decision. And that turns into a letter that your client receives, whether they receive it online or if they receive it by mail. We recommend that applicants try to be present for the inspections. This is FEMA's statement as well, I understand. And we emphasize it's important because your client needs to be there to verify their ownership and occupancy of the home, show those documents then. If they cannot be there, we had this at times when people were displaced, let's say from Hurricane Katrina, and they resided in Louisiana and there were inspections taking place there, but they had been displaced to San Antonio, Texas, where we were working with them. They couldn't be there for the inspection. So we would, suggest they designate someone they trusted to be their representative for that inspection. Know that the people that are doing the FEMA inspections, while they're acting as agents of FEMA and they're providing the information about their observations to FEMA, they're generally not FEMA employees. FEMA contracts with 2 companies to provide inspectors, and they're independent contractors. And at least historically, based on the documents that I reviewed, the only requirement was that the inspectors have passed a criminal background check. And we're talking a federal government ones, but a background check. While I understand that related experience would be preferred, and no doubt many of the inspectors actually do have some different bases of knowledge about construction and being able to evaluate damage to homes and such, it is not required. So there are also FEMA inspectors who are making decisions about the damage level to a home, whether it makes the home safe or not safe and such, that do not have that experience. And each and every one of the inspectors, their findings are controlling aspects of who is and isn't eligible for assistance. The training that is being provided to these inspectors, I've heard varying things. I don't know what it consists of right now, but when I looked into this in the past, it was something along the lines of like 8 hours of training on FEMA standards. So if you think about what you would like an inspector to know going into your home to assess whether or not certain damage was caused by an event and makes it safe or unsafe, and how many square feet of damage on this or that were affected, and that you know, how much training would be helpful for them to have. We understand that the inspectors do not, they're not allowed to get on a ladder to view the roof. They do not get underneath the house to say, take a look at plumbing or problems with leveling underneath the house after flooding. And so that just affects how the assessments are done. In the past, records showed that there were bonuses if inspectors hit certain quotas. So there was kind of incentivizing moving quickly to get these done. But we've heard reports from clients about that, meaning that inspectors were moving very quickly through the home. So I'm sure there's a lot of variation, but again, whoever the inspector was for a particular case is affecting the decisions for that client. And then we've had clients deal with language barriers. Some of the counties that we work in and the Rio Grande Valley, Texas-Mexico border, many of our clients primarily communicate in Spanish, but they were not necessarily having their home inspected by someone who spoke Spanish. So while FEMA had not required inspectors to actually get a detailed explanation from the applicants about what damage there was to the home, it was the only opportunity the applicants really had to try to communicate about that. Please look here, please look there. And if they couldn't communicate because of a language barrier, it kind of hampered that process as well. During COVID, you know, is FEMA still sending inspectors out to homes? My understanding is no, that there is a process for remote inspections. That's more than I'm going to be able to get into today, but I definitely please let Kathy know if you have information about how this is actually working right now in Florida. I know some advocates in Iowa have been dealing with this as well. So just those of us that have, or those who have responded to federal declarations this summer are probably going to have more details about that, but there is a fact sheet up about it. And then some guidance that FEMA put on their website about how they were preparing to operate during this hurricane season that feels never ending at this point. So. Okay, moving on. After an inspection has been completed, however it got done, then they should get a letter from FEMA. Again, people could be receiving this electronically online if that was how they expressed their preference, or it could be by mail. And the decision letter should let them know the decision FEMA made, the amount they're going to receive if that is, if there was an award, and they could get a check, or if they opted to have it deposited into their bank account, then it could appear there. There also is a chance your client could get a letter from FEMA saying, hold on, we still need more information. Please send us X. And I've generally seen it as a form letter that says, you know, a list of different kinds of things. So figure out which one actually applies to your client. Some of them will have NA after them, but there's usually a deadline. So watch for that to make sure that you can support your clients in supplementing those requests. Okay, when benefits are awarded, know that they're not taxable. It does not count against means tested benefit programs. And sometimes we have to watch out for that. And then it should not count in the public charge context. It should not have an immigration consequence there. That is subject to change, but right now that was the last we heard from executive order. The money is to be used for its intended purpose. So FEMA, when they're sending them the letters and they say this money is for transportation assistance, that's not to repair a home, that's for transportation assistance. Folks need to keep their receipts and kind of the documents that support how they spent the money for at least 3 years, because FEMA can come back later and ask to see those receipts and seek to have it repaid if they believe that the person wasn't eligible for the benefits or if they were not used properly. Also, in these decision letters, when someone receives benefits, look for language about whether or not your client is now subject to a flood insurance requirement. Many people who get benefits from FEMA are not subject to this requirement. This is only for people who live in a special flood hazard area. But if you're talking about a flooding event, particularly, look for that. We do see those once in a while. And when that language is in there, it's something along the lines of, you can keep these funds, but then you are thereafter required to maintain flood insurance at your own expense. And if you don't want to be bound by that, return the money. So your client needs to understand that. And okay, if your client disagrees with any aspect of the decision, appeal. And I mentioned some of the things I did about the inspection process because that, in my opinion, makes it really important to appeal. Just because FEMA's assessment in the letter says your home is fine, we don't really think that the disaster caused it to be damaged. Was it because the inspector didn't really do a great job? I mean, it's worth getting the facts and laying them out in order to challenge that decision if your client's concerned about it. And there's other types of things that issue in appeals too. I'm just offering that as an example, and I'll give some more examples shortly. The appeal should be faxed, postmarked. It is a written appeal. Generally, there's not a motion for continuance or a motion for extension of deadline where you're going to get a formal response from FEMA saying it's fine, you can submit it late. My practice is if we are having to do something and it's very urgent, maybe the client came to us days before it's due, you file that thing on time if at all possible, but you ask for time to supplement within the document. And then you act as promptly thereafter as possible. No guarantee, but it has been honored generally in past disasters. And if it's already late, is there any good cause for submitting it late? Take a shot at explaining why you hope FEMA will consider it late and, see what happens if you've got that kind of an argument available to you. Common issues. Navigating a bureaucracy is hard. And I'm guessing for most of the folks that are watching this now, I mean, we may know it's hard, but we also may be people who are pretty comfortable doing it because it's part of our job. We may work within a bureaucracy or as advocates, just know that's part of what we do. But if you put yourself in the shoes of a disaster survivor, and particularly somebody who is not accustomed to dealing with bureaucracy frequently, they may be traumatized by the event they just went through, the losses they've sustained. And so it is difficult then for them to begin processing, well, in that state of mind, the multiple bureaucracies that they are going to have to deal with. Maybe they are having to deal with their insurance company and they are working with the Red Cross and applying with, a church helping them with these benefits and this other organization. It is really common for disaster survivors to feel confused because they've shared their information with several people because it's hard to understand what's happening in a process that presents to them in a very piecemeal way. And then, like many bureaucracies, there's jargon and acronyms, and the FEMA decision letters are not, a narrative that explains the facts underlying the FEMA decision. There's a code and a brief explanation. You talk to more than one person about the FEMA case, and you might get different information from different FEMA employees. Some have been with the agency a while and know what they're talking about, and some may have been hired more recently in response to newer disasters, and your client may not know which one knows what they're talking about and which one doesn't. So that can be frustrating to kind of sort through, but it's just part of it. And they may feel kind of bounced around the system. I mentioned that in Texas, the state actually makes certain decisions. So sometimes, folks would talk to FEMA and want to know something about housing assistance, and then they'd want to know something about the non-housing part of their FEMA application. And they were told, well, you got to talk to the state. They didn't understand that distinction, and it wasn't really laid out really clearly for them. So that's how this kind of feels for your clients as they're going through this. No news is not good news. It's possible that if your client says, I applied with FEMA a while ago, but I haven't heard anything, maybe they're waiting on an inspection. After Hurricane Harvey, 2017, and the series of disasters that happened afterwards, it was taking a while for inspections to occur because there were so many to be done. But it was worth us calling FEMA to find out, is that the problem? Because it could be that your client had received some kind of FEMA decision and it was sitting in an online mailbox and they didn't realize they had opted to receive electronic communication and were watching their mailbox. Could be an error, just a typo in the mailing address. There could be other types of things to be corrected. Or when my clients tell me that they heard about the housing assistance part of their application, but gee, I haven't heard whether I'm going to get assistance for my personal property that was damaged or my vehicle that was damaged. That always kind of is a red flag for me because that is the type of disaster assistance that is SBA disaster loan dependent. Did my client fill out the SBA loan application? A lot of people don't because they think, I don't have money to repay a loan. I don't want a loan. But this is one time when I am advising low-income clients who don't want the loan, don't think they can repay the loan, to apply for the loan because it's part of this process. They have to be turned down in order to be considered for this other assistance. And I also assure them, if I'm working with them, if for some reason you're approved and we think there's an error there, then I will look at that for you as well. And we'll see what we need to do and to turn it down if we have to and figure out the consequences. But just a big thing, if they're saying, I haven't heard anything, there could be a reason. So just look closer, consult someone if you need additional information. Okay, we have this come up a lot where there are denials for insufficient damage. And this comes up in housing situations with the language, your home is safe to occupy. We're not giving you home repair assistance or rental assistance because the home is safe to occupy. This indicates that the FEMA inspector who visited the home made a decision that the home was habitable. And that means they thought it was safe, sanitary, and functional as FEMA defines those terms. Okay, so if your client disagrees, a little bit more in a bit on how to appeal that. It could be that FEMA thinks, again, FEMA inspector who made those fact findings, well, the home isn't habitable, it maybe wasn't safe or maybe isn't functional, but the repairs are not that expensive. We think you can afford that. Well, FEMA has published its $50 rule. If those things could be repaired for $50 or less, they're not going to issue a check. Or it could say that, well, and I should be clearer. The language in the letter actually is a paragraph that combines these things. Your home is either safe to occupy or it isn't safe, but it's not that expensive, or it wasn't disaster related. So you kind of have to guess as to which of the reasons is underlying the decision in your client's case, because you have to kind of, it could be any of those. In any event, if they say that it is, if it's about it not being disaster related, maybe the inspector viewed some damage to the home as making the home unsafe, but didn't think the disaster caused it. Do they think that it was caused by pre-existing damage? And so that gets more complicated. But a home repair decision that actually results in an award, but the award seems strangely low compared to the damage your client sustained from the disaster. You know, you have to check your client's expectations. This isn't insurance, but it also could be the same factors I just described that result in outright denials for some people, kind of depress the amount of FEMA assistance that others receive. You know, a client that gets $99 for home repair when they have $10,000 worth of damage. You have to look then at what's going on. Okay, and this picture of a client's home, and we had a hole in the ceiling, we had damage and that in corners. There are other photos, I just chose a couple of these, but they got one of these letters that was saying insufficient damage and received zero assistance when there was a contractor estimate asserting that it would take $10,000 to repair and the damage that the storms had caused to their home. The goal of these appeals, when we're talking about an assertion of insufficient damage, is to seek that FEMA re-inspect the home. Okay, FEMA is not going to look at the estimate that you submit from a contractor saying it'll cost $10,000 and send your client a check for $10,000. They're comparing those things to see if there is enough to make them second guess what their inspector had thought. And if so, then they can send another inspector out to decide things anew using FEMA standards. So you do have to have supporting documents when you are disagreeing with FEMA's damage assessment and saying that they got it wrong when they gave you a low amount or denied it outright. You also need to have a sworn statement from your client explaining in their view what the damage was and why that makes the home uninhabitable. And then expect that FEMA will call the contractor. It doesn't happen in every case, but it may be that you've got a contractor that has explained the different itemized damages to the home, but FEMA wants to make sure that the contractor believes that it was caused by the disaster or something. So just be aware of that. If they cannot get a hold of the contractor, that might prevent them from issuing a new inspection. So it's an important thing to be aware of. Lawsuit that my organization was involved in resulted in a finding that there were some additional standards inspectors were being told to apply when they thought there might be pre-existing damage. This is not part of anything that FEMA has published since, and FEMA asserts they're doing it differently, but I don't know what additional standards they are using right now to decide what is and isn't disaster related. But in 2008, for a number of clients in the Rio Grande Valley, if they felt that there was some pre-existing damage, they were not to record damage as disaster related unless the damage was significant, obvious, and without question. And this was viewed as kind of affecting the burden of proof. So this is some of the concerns that we've had about inspections and why appeals can be worthwhile. Okay, other denials entirely. Moving on from the other topic. If it says that your client's application was withdrawn, was there a problem with meeting with the inspector? Maybe the timing didn't work out. Maybe there were some communication issues. You appeal and say, they're still interested, didn't intend to withdraw anything. Can we please set this back up? And that has been successful in the past. If they were denied rental assistance and it says they're not willing to relocate, you might talk to your client about, well, how did the inspector put the question to you? Did you understand that they were asking whether you were willing to relocate temporarily? Because sometimes people hear, are you willing to relocate? No, Corpus Christi is my home. I don't want to go to another place, and they don't really get the context. So just explaining in a letter what your client is willing to do helps. Failure to verify ownership. FEMA's standard for who is an owner is not the same as clear marketable title. They don't have to be the one and only owner of the home, but they can show that they meet the standard if they are the legal owner, if they are a life tenant. Sometimes we are using laws related to inheritance to establish those kinds of arguments. And it is also possible to demonstrate that they're the owner if they lived in the residence rent-free and were responsible for property taxes or maintenance, which I understand has meant major repairs. It's important to note they had to be the owner at the time of the disaster. So if you're preparing paperwork afterwards, you have to understand and be able to explain why it is indicative of them possessing the necessary interest at the time of the disaster. Not, hey, you know, they own it now, we have a deed. It's a little more complicated than that. And inheritance laws, people maybe didn't probate or deal with heirship or something until after the fact, but they actually inherited the interest earlier. That can help, but you know, you're going to have to lay out the argument and everything clearly. If anybody has questions on that, please feel free to let me know. Okay, only one person for the pre-disaster household is to get benefits, but sometimes people have to kind of split up after the disaster because of, let's say you had grandma and grandpa, mom, and 3 kids living in a single home before the disaster, but after the disaster, grandma and grandpa found one place and mom and kids went somewhere else for a different reason. You can argue about with FEMA about why they should each be entitled to separate benefits, but in general, that's going to be more difficult. There are some nuances there where they might get certain forms of benefits, but in general, the program is set up to expect everyone to stay together. Also, when it says duplicate or shared household rule, it might just be a matter of trying to understand the facts. Were there really multiple people in the same household, or are there more than one people using the same address? So is there like a plot of land and you have a structure there where mom and dad live and a mobile home where mom and 3 kids live? Well, if you just explain there are 2 households, even though we have the same mailing address, that could be established with an inspection or other paperwork. So just look a little bit more closely. We've even had situations where people living in the same mobile home park all had the same mailing address, but we explained and we're like 8 different lots and we had to kind of sort that out. So just look closely at what the facts are. Insurance, bottom line with insurance stuff is understand what insurance your client has and doesn't have. And then sometimes I've had clients who really didn't understand they had insurance at all. Maybe they had forced placed insurance through a mortgage and they didn't know because they didn't procure it. So asking those questions, looking through paperwork, and then explaining to FEMA if you think there's an area that was not covered, so that FEMA can then consider meeting the client's needs on that front, even if other things are going to be covered by the insurance itself. And And then non-compliant with flood insurance, that is a sign that you have a client that maybe in a previous disaster were affected by flooding. They got FEMA assistance a while back and were told then, now you have to maintain flood insurance. And if they didn't, they are going to be really restricted from what they can receive now. I'm going to stop short of saying they can't get anything, but you would have to closely review the rules to see how those decisions get made. The obligations also for owners that run with the land too. So just be aware of that. There's some aspects that apply to renters, but it's a big deal if they were told that. I'll also note people that do get notice that you have to get flood insurance. FEMA has, in some situations, group flood insurance policies and can provide for low-income clients free flood insurance coverage through that type of policy for a 3-year period before the obligation shifts to your client to maintain that. So look into that if you have somebody that's affected by one of these requirements. Personal property, just like in the housing context, there are some rules that we think FEMA uses that makes it harder for people to get the full amount of housing repair money they might need. Personal property can operate the same way. So if your client says, I don't know why they gave me $25 to replace my personal property, always look at managing expectations, essential, necessary, but your client's going to need to prepare a list of what was damaged and make that an appeal exhibit and revisit that with your client to kind of explain what the items were, why they were important, how the disaster is responsible for that damage. And then it's important that the property be available for the inspector to verify the losses. Again, FEMA's inspectors are the eyes and ears, and they're making these fact findings. And so if the client says, I had these things, but they're moldy, I threw them out. Are there pictures? Is there something else? Be creative about the evidence that you can offer to help verify that those losses happened, but that is tougher. Appliances, stove isn't working in that. You may need to get estimates from a technician who's going to attest to what is damaged, what it would cost to repair it, and tie it in with the disaster. Transportation assistance, the cases I've dealt with most, is it an essential vehicle? So let's say you have a household of 2 adults, but 3 vehicles. If all 3 were damaged and you're seeking benefits on that, that's going to be harder to establish. Why did they need 3? But if you have 3 drivers in the home, everybody goes to work somewhere separate, and you can explain why they were all essential, perhaps. You have to have a street legal vehicle in order to be eligible for the transportation assistance. So if it wasn't registered, if it didn't have the insurance as required under state law, that's not going to work. It's not going to take care of repairs that are about cosmetics, but if it's a safety hazard, a mirror was knocked off by a tree that fell during the disaster or something, or if it's not working, water in the engine and such, those are the kinds of things that could be dealt with. You're generally going to need estimates from a mechanic to establish, I think, causation and amounts and, itemize so it's clear what's cosmetic versus safety. And then if it was totaled, there's like a fixed amount for replacement that is not about the value of the vehicle itself. It's about what it would cost to replace and have something functional. It's not insurance for that particular vehicle. Practical tips. I'm going to not go through all of this in detail, but this is something for y'all to kind of go through. And I want to leave a little time for questions. Do your investigation, and that can include your request of the FEMA file. Make sure you are doing the issue spotting. Your client might come to you with what they're focused on right then, but not even be aware that they might be eligible for another form of assistance. So be comprehensive in how you interview them. Talking to FEMA is important to understand more about what's going on. And understand when you call FEMA or you talk to someone at a FEMA disaster recovery center that's temporarily open in the community, that's not the person that's making all the decisions on your client's case. It's not one caseworker that's in charge of it forever and ever. And a lot of different people touch the file. So just understand as you're asking questions, they're kind of interpreting the notes of whoever worked before them. It's a list of the kinds of things you'd include in the appeal packet. I'll leave that for you to refer back to. Addresses that you can use in order to submit appeals. I do not submit them online. There have historically been some problems with that. Perhaps that'll be resolved in the future, but my recommendation now is by mail, certified mail, or by fax to be able to prove that it was sent and received. And then it's not over when the appeal has been sent in. You need to check the status of it, make sure it was received. Generally, when we've made these phone calls, sometimes we're told it's received and it will take a while for the decision to be made. Great. Sometimes there are occasions we need to troubleshoot something, like we're trying to get a hold of the contractor who signed this estimate, and gee, we can't get a hold of them. Okay, we'll call the contractor and make sure they know what's going on so they call you back, or there could be other things. And then sometimes we've had trouble getting decisions in writing. So push to receive that. You should be able to get that so you can kind of figure out what the next steps are. And then communicate with your clients. FEMA will continue communicating with your client. So you need to work out with your client who is going to be checking in with FEMA, and you don't want kind of too many cooks in the kitchen and it gets confusing. FEMA told one person this and something else. So get that straight. The decision letters do not go to the attorneys either. They go to the client. So make sure your client knows to let you know. Sometimes they might think you got a copy too and you didn't. So can you appeal a second time? The regs say one. Generally, we do appeal a second time if we think we have something new to say. And informally, FEMA's advised us that if there's new evidence, they can consider it. So I don't shy away from doing second appeals, but only if you really have something new to present. There are some occasions where we think, gee, we really think they got it wrong. So we may try that as well. And then if you were doing an appeal for a different reason, let's say you appealed on rental assistance and now you're appealing because of personal property or something, absolutely. We're talking one appeal per category. So, okay, and this is my last point, and this is a bit snarky, but I do this to make the point. I have been kind of challenged on the idea that attorneys are needed to work on appeals in the past. Why does your client need a lawyer? But FEMA is an administrative agency like Social Security Administration, Immigration, the IRS. Not everybody needs a lawyer for these things. Some people may do very well working through the system on their own. Some might do fine at first and then encounter an obstacle and want a lawyer. But a legal professional is going to spot issues others don't. Maybe there are some, landlord-tenant issues that are going to pop up with a problem getting rental assistance inspection done. And, so a lawyer is going to be able to kind of point them in the right direction on the other issue. But also there could be some ways that a lawyer is going to think to address issues based on the FEMA statutes, regulations, and policies that are different. And so we have found these to be challenging cases in the thousands or so that have come before us in the last 18 or so years. So we think it's really important that people be connected with advocates where possible. And I just have some examples here of some press releases that FEMA has issued in the past that are, I think, I'm speculating, but the intent to make appeals sound accessible, which is a great instinct. We want people to participate in this process and not be discouraged. But I think sometimes that has the effect of our clients feeling frustrated because it seems like it should be easy. What am I doing wrong? Never mind, I can't handle this. And if they get connected with an advocate who understands how to kind of navigate the process and what certain codes in the letters often mean, what common problems are, strategies, then it can empower them to keep pushing in order to establish eligibility for those decisions. And then some federal courts here, some quotes, critiques of the FEMA regulations that have been issued and are largely still in place all these years later, about kind of, it's hard to know what some of these standards are. So again, for lawyers and advocates that are listening, if it seems difficult in some ways, I mean, it actually is. And so I think it's important for us to be involved to empower our clients to work through the process. And just in general, I think it's important to acknowledge that there are some difficult aspects of the process. There are some standards within it that we don't know, that are not published. And so that can make it harder to know when to appeal and when not to. And so, we tend to take a shot, but clarity about whatever standards are actually underlying it would be really helpful. But we don't have that at this point. So, okay. If you have questions, please let me know. And if there are questions now, Kathy, that you want to ask me, I'm ready to do that.
Okay, yeah, we have one question here. Then we were talking about the inspections and someone in writing, do you find that FEMA inspectors often under-assess damage and benefits eligibility, and survivors are expected to get the appropriate relief through the appeals process. They start out maybe lowballing and just see what happens.
I don't know about the latter aspect of it, but I think it's how it's messaged, right? You know, if the inspector doesn't get it right, that's okay, appeal, without fully appreciating how difficult it actually is to kind of pull the appeal together, particularly if the person doesn't have an advocate who is going to help kind of package and present and focus on what the right issues are. So I can't speak for what FEMA's intention is with how the inspectors are sent out to do it, but in practice, like I've explained kind of how I perceive it to occur.
All right, thank you. Second question, can you talk more about the unpublished standard in LUPE, and what was the legal argument you made to get the court to ignore that standard?
To ignore this, well, okay, so we made a variety of claims in that lawsuit, but the decision that the court made that was helpful to our clients was that FEMA is to publish rules under the Administrative Procedure Act. And so and rule is defined specifically within the Administrative Procedure Act, 552. And so we argued that the regulations themselves that FEMA had published did not provide enough information to control the outcome in these cases, that there must be more underlying it. And we were also pointing to some informal communications we'd received where our clients were told in a specific case, your home has deferred maintenance. It's not in any of the regs. It's not in the IAPCA. It's not in those published things, but a FEMA spokesperson did say those words in a publication in South Texas and explained that there was a higher denial rate than normal in that community because of the substandard condition of homes in the colonias and because of deferred maintenance, something along those lines. And so it took years to litigate that case, but we were able to do some discovery, kind of fast forwarding through some stuff, but as part of that discovery, we saw that there were then training materials and manuals and stuff that FEMA had that were provided to inspectors, but not the public, not part of the regulations, that said, inspectors, if you see there is evidence of deferred maintenance, then you need to not record disaster-related damage unless it is significantly worsened by the disaster, obviously, and without question. So that FEMA can make the standards it wants to make, as long as they're following these procedures. Our concern is that that standard wasn't published, that we had to litigate for years in order to discover that that was the standard that controlled it. There also had been, and I understand it's not the case now, and I don't know what all's in the system now, but the FEMA questionnaire that inspectors were to complete during that 2008 disaster actually had a section where they were to mark off areas of the home where they viewed deferred maintenance. And so there were 24,000 out of 38,000 applications that had at least one area of deferred maintenance marked off. So our argument was that that was really impacting how much assistance many people were able to get for home repairs and that. So.
Okay, yeah, okay. That, and a follow-up to what you just said is one of the viewers said, what is deferred maintenance in that context? Does it really mean that the repairs were put off pre-disaster?
So that's one of the things that we would like to see defined by FEMA, right? And our litigation position has been that the documents that FEMA publishes doesn't show us, or any of us that are advocating on these cases for clients, how they wrestle with dual causation, right? Those of us who are lawyers go to torts class, and how do you decide that one thing or another was responsible for a certain effect? Well, you can have situations where a home wasn't in the best state of repair, and particularly low-income clients may not have been able to fix their roof for a while, but it was functional before the disaster hurricane comes through, now there's a big hole, and then it's really not functional. The disaster changed things and took the home from habitable to non-inhabitable. Is that disaster related? If the term disaster related has no meaning underneath it other than just those words? Yes, but how FEMA wrestles with the idea that pre-existing causation is in the mix, I can't tell. I can't discern that from what FEMA has published in their regulations right now. Particularly, I think it's 206-117 has to do with the housing assistance standard. So if y'all are curious, I would check that out. Look at the FEMA IAPCA that's published and how they explain what they look at as disaster related. But I don't see that question wrestled with there. And the materials that we were able to view through the litigation that explained this other standard explained more about how they were wrestling with it. And whether we like that standard or not, that was the standard. We wanted that published, and we felt that under the Administrative Procedure Act it should have been, and the federal judge agreed with us on that point.
All right, I think that we have answered all of the questions that we had today. So Tracy, thank you so much for presenting today. It's a lot of good information. And a lot of good information on the slides that you presented and that everyone will be able to get a copy of. So thank you very much. Thank everyone who attended today. I hope you'll come back next week. Again, next Thursday at noon, our program is going to be on FEMA recoupments. So when FEMA is trying to get back some of the money that you were able to get your client for, but now they want a little bit of it back, or maybe all of it. So that's next Thursday with Lauren Tuggle from Southeast Louisiana Legal Services. So we'll see you then. Thank you for joining. And again, thank you, Tracy. Bye-bye, everybody.